Okay, so hello everyone, and welcome to today's session on environmental clearance process. I am Anusha Srivastava, Instructional Design Initiative. We provide on-demand legal education for everyone. We at EBC aims to help remove hurdles to legal education, to empower you to make life-changing moves, and to help you learn and win. Our courses are available at ebclearning.com. Now, I'd like to introduce you all to our presenters for today, Professor Bharti and Mr. Shashikant Yadav. Professor Bharti is a professor of law at NLU Delhi, and she heads the Center for Environmental Law, Policy, and Research. The center has facilitated and conducted national and international deliberations on natural resources, regulations at grassroots level, as well as within the institutional framework. The center, under the leadership of Professor Bharti, has conducted the much acclaimed training program for professionals and academicians on environmental law. She has been working on natural resources policies in collaboration with lawmakers, members of civil societies, and interdisciplinary researchers to provide innovative solutions and platform for deliberations. She has also been actively fostering implementation of sustainable regulatory framework within the nexus of energy and environment, constitution and environmental rule of law, and judicial approach to environment in India. Welcome, Dr. Bharti. Sh- Shashikant Yadav is an oil and gas law specialist with 5 years of industry and teaching experience. He is currently associated with the University of Dundee, Scotland, as an academic researcher. He is also selected as a recognized scholar with the Center for Social Legal Studies, University of Oxford. He is a consultant with NLU Delhi Center for Environmental Law Policy and Research. He has been associated as a researcher with IIM Ahmedabad on Supreme Court analysis of India's energy sector. Also, he has been a part of editorial board at National Green Tribunal Reporter and was felicitated with a plaque of honor by Bar Council of India and promoting clinical legal education. Welcome, Shashikant.
Thank you very much,
Now, now
Anusha.
let's take now let's take a goals for us. So, as we all know, the government of India has recently released a draft environmental clearance process, bringing in substantive changes in the clearance process. Environmental clearance is a matter of great significance in corporate law and due diligence. A significant number of litigation policy research projects are happening on issues concerning environmental clearance. With incidents like Vizag gas leak, an understanding of the environmental clearance process is imperative to not only the researcher but to practicing lawyers and law students. Now, this session aims to provide working knowledge on environmental clearance process in India and understanding the proposed amendment in the environmental clearance process. So this is what the session will hold. Now, before I hand over the control to our presenters, just a few preliminaries I would like to go through. This webinar is available on demand, and a recorded version of this webinar will continue to be available on our YouTube channel at youtube.com/c/EBC Learning. We'd of course love to hear from you, so stick around for the question and answer session at the end of the presentation. You can send us your question through the chat tab at the bottom of your player, and we'll take up the questions from there. While the presentation is going on, you can still send us your questions, and we'll be noting down the questions, and we'll be taking up all the questions at the end. So in between also, you can send us the questions. At last, I would encourage you all to share this today's webinar on social networks. You can use the social sharing icons in the email invitation that has been sent to you. So, without any further ado, I'd like to kick things off by welcoming our speakers. Over to you, Shashikant.
Thank you, Anusha, for a wide and generous introduction for both of us. First of all, happy Environment Day to each one of us. Stuck with, uh, hello, I think I lost the connection. Am I audible?
Yeah, you are audible.
Okay, there was a hang, I think, therein. So first of all, I will begin with wishing all of you a happy Environment Day, and strategically our seminar fell on this day, which is a great thing. And so to begin with, I have a small presentation which will help you to navigate through what we are trying to do today. And we all know that there is a new regulation, a new notification which proposes the change in environmental clearance process in India. And our discussion on this notification is really important to highlight what are the changes which government is fostering. And after COVID, the economy has taken a background, as we know. And before COVID itself, the economic growth in the decade was one of the lowest. And hence, there is an emerging need to boost the economy. However, will environment pay the cost of such a boost is what we are going to discuss. And whether this EI notification, the new one in 2020, is a boost to such economic activities is what we are trying to highlight here, and how we as scholars, researchers, or readers, or general concerned citizens can put in our efforts to make sure that we strike that sustainable development balance between economic activities and the environmental protection. So to begin with, how we have structured is that Dr. Bharti will take us to the jurisprudential route or the evolving route of environment clearance in India from international regime, and how it basically found its place in India. And after that, we will end up discussing that what is the procedure, step-by-step procedure of environment clearance in place today in India, and what are the changes the government is making and government is proposing. And we are not aiming to force feed our opinions on people. We want you guys, whoever joined us, to have a very, very balanced viewpoint on the new environment clearance process. The comments, the government is inviting comments from each one of us. And if you want to, after this session, comment to this, you can send the comments to the government. We want people to engage more and more with the government on the new environmental impact assessment notification. The comments are open till 30th June. And after the seminar, you have good 20-25 days to read through it, to analyze it, whatever information you have from us. And if you want to connect with us after the seminar, we'll leave how to connect with NWD Center and how to process the whole information. So this was the aim and scope with which Dr. Bharti and I are approaching you for this seminar. Would you like to take over, Dr. Bharti, with
Thank you, Shashi, and thank you, Nusha, for this opportunity on a very significant day that we are celebrating a very safe and healthy World Environment Day to all. And the theme for today, which is environment impact assessment, undoubtedly it is a very potent tool in the armory of for preventive environmental management and governance. And it really involves all the stakeholders, which is the project proponent, the regulator, and the people at large, especially the people who are affected. So it's a common objective of all to try to have a project which is in consonance with the environmental, say, the ecosystem, and not to create any kind of adverse effects or consequences which are going to have a long-term problem for the around the located in that region. Now, when we're looking at EIA, it has really a twofold objective. One is to inform decision making, to help in the processes of executive, the for the purpose of the regulatory authorities, that they are able to decide whether the particular project should be given the green signal ahead or not. And secondly, to aid in the long-term objective is to help in the process of sustainable development. So here, I think both these objectives, how to correlate these and how they have emerged over a period of time. It's not over the night kind of a situation. There's been a whole history to this, to the emerging concept of EIA. And I think it would be interesting to really look back at the starting point, which is the national the NEPA, which was enacted in the US in 1969, and which really became the forerunner to the entire this working, the operationalizing of EIA as we are aware of. So when we're talking in the international context, Stockholm Declaration, the Stockholm Conference, which took place in 1972 and which really initiated the international journey of environmental laws at the global level, we find there is not too much, there is no specific mention of environment impact assessment or even the term sustainable development. But it is not that this particular document or this particular conference, the declaration that came therein, were bereft of any kind of connotations or some kind of connections. And there's specifically principle 15 and 16, which really give a kind of a structure or some kind of concept which emerged later. And you find there was a lot of there were many events that took place post the Stockholm. There was a Brundtland Commission report, which came in form of the Our Common Future, in which the concept of sustainable development was clarified and was highlighted. There was the Rio Conference of 1992, in which Principle 17 it accentuated, it highlighted again the proper, really the understanding of EIA. And thereafter, we find the Agenda 21 in Chapter 8, the Convention on Biodiversity, Article 14, the Convention on Climate Change. Now, there we have certain interpretations through Article 4, Clause F, and in the Kyoto Protocol also, where it can easily be derived that EIA is an important precept. Even the Ramsar Convention, which is one of the earliest international conventions and which came up in the 70s, it later it incorporated EIA in 1999 to the Conference of Parties, COP7. So you find that World Bank, of course, and various development banks and aid agencies have over a period of time integrated environment impact assessment through their policy formulation when giving aid and assistance to various projects. You have the EU, which has implemented the EIA directive of 1985. And there is a very important Aarhus Convention, which came up in 1998, which really which outlined three important limbs to environmental issues. And it is, if we connect to all these three issues in the present context and in any legal system, I think it finds its application. The first very important limb is of public information. The second, equally, all these three limbs are equally important. And second limb is public participation in decision making. And the third aspect is access to justice. So all these are three, they are concomitants, and they are very, very important parameters, and they play a significant role in galvanizing, in strengthening the environmental, the governance of a particular country, because especially when we are looking at public participation, this is really the heart and soul of EIA in any country, in any legal system. And it has been adequately understood through the RS Convention, although India is not a party to it, but it finds its application in India too. We have the kind of law, the legal structure, which gives due emphasis to all these three limbs. We have the Right to Information Act, we have the Environment Impact Assessment, the notification of 1994. And in terms of access to justice, we have the Specialized Environmental Tribunal, which is the NGT, National Green Tribunal, as well as the Apex Court, the Supreme Court, and the High Courts, which can which can look into the issue of environmental, any kind of complexity, any kind of litigation pertaining to it. So I guess, yes, Shashi, you can carry on from here, because this was a little important to give a kind of background to this concept and how it has made its presence, internationally, and it has now been part of the Indian legal scene since 1994 in a more structured manner. Even before it, it wasn't that it was through administrative exercise that it was present, but now we have a formal structure that is there.
Thank you very much, ma'am, for laying down the basics of, of how EIA developed all across the world and how it became such an important tool. So now coming back to the Indian scenario and how India is adopting an environmental clearance process, we need to know that since 1994, we wanted a regulatory framework through which we pass new projects. So we have had notifications since 1992, in 94, in 96, in 2006, there was a notification which is considered like a grand norm regulatory authority for environmental clearance. And now in 2020, we are trying to develop a new regulatory framework. Now, to understand what was there previously and what they are trying to do afresh, we need to do a comparative matrix. We need to know how environmental clearances are given today and what are the changes they are trying to make, what are the rationale of these changes, and how as citizens we can contribute to make an informed choice. And that is why the government is open for public comment, and that is why an informative collaboration needed to be done. So now, if you could see the screen, there is a scary flowchart with a lot of branches coming out of it. And let me just sum it up that how an environment clearance process happens in India without going into too much of detail. So if you see to the left of your screen, there are four stages which have been elucidated: screening, scoping, public consultation, and appraisal. Now let's imagine that all the participants are about to start a new factory and you want to manufacture, for example, pharmaceutical factories, because this is what the government says, that we would be needing more pharmaceutical units, we would be needing more PPE manufacturing units, and we need to make more factories, and India should be hub of supplying those. And rightly so, we have done that in past. We have supplied a lot of medicines as during COVID outbreak across the world, and we want to be a manufacturing hub in that way. So we need speedy environment clearances in that context. So so if you want to establish a factory right now, first of all, you need to get the land. You need to do a site selection, and you need to know which state you would want to approach for getting the land, because under Indian constitution, land and water and air is a coordinated subject matter between state and union. So there will be particular land laws, land related taxation in a particular state, and as a consultant to an organization or an NGO, you would like to know that what are the laws in, for example, Punjab and Haryana, if you want to establish one in Gurgaon, or what are the laws in Andhra Pradesh. So the first step for EIA is, or to start your factory, is site selection. And once you have reviewed laws of a particular state, that this is the compensation that I have to give to tribal people, this is how long a state takes to give land clearances, this is how long a state takes to give me the water testing, and all those measures, and all these metrics are available online. And then you select which state to choose for investment. Now, once you have selected a state for investment, you acquire that land primarily, and you enter into a lease, or you show an intention to enter into the lease. Now, once the land issue and the site selection is sorted, you want to get permission for establishing your factory. So the first and foremost thing will be construction of the factory. Now, this is where the EIA starts playing an important role. in EIA 2006, and with EIA means I mean environmental impact assessment. That means what is the impact of your project on environment, you're assessing it. So in that situation, EIA 2006 says that the only activity on the piece of land that you have owned or you intend to enter into lease, the only activity before getting EIA is fencing of it. You can only fence it. You can demarcate a boundary. So if you have bought a 5-acre land in Andhra Pradesh, without getting EIA, you can only draw a fence against it to the boundary, nothing else. You can't do any kind of temporary construction there according to EIA 2006. You can't do any kind of operation therein. And once you have done the fencing, you can approach the government with your application for environmental clearance. Now, where do you find this application? This application is an annexure to EIA notification 2006. You can go to ministry website, which is Ministry of Environment, Forest and Climate Change. There is an annexure attached to the notification 2006, which is an application. You fill in that application, and that application demands all kind of information. That what is the status of your land ownership, who is the project proponent, what is your investment, all these kind of information, which you need to know before starting any kind of environmental clearance. Now, once you have filled in the form, in that situation, you would be expected to know how big is your project. So in Environment Impact Assessment Notification 2006, there is category of project. If your project is huge, big, humongous, have a proper impact on people, then your project will be monitored at central level. Union government will monitor your projects. For example, there are ultra mega power plants by Adani's and Ambani's, which deals with mining of the coal to transforming into energy. All that will be dealt by the union government. Now, how will you know that whether your project will be dealt by union government or not? That is why we have something called Schedule A and Schedule B. There are A-level projects, there are B-level projects. A-level project go for the assessment depending upon whether the project falls in category A or B at state level and at the central level. Right. So if your project is smaller in nature, if its impact only affects a state, it will go for a state level approval. If it goes for a higher regulatory, it will go to the union. So as an environmental lawyer or a consultant, go through the list. The list is very exhaustive. So for example, if your power plant gives more than 5,000 megawatt electricity, or if you tend to acquire more than certain acres of land, it will fall under A. Or if it is lesser in magnitude, it will fall under B. So consult Schedule A and B of the list of Environment Impact Assessment Notification 2006. And after that, submit your application. Once you submit an application, if it is a project A, the union government will have a central level impact assessment authority. It will review your project, review your application. And if it is category B, it will go to state level and it will start reviewing your application again at the state level. Once it has been reviewed, now comes the whole gamut of complication. Now, if your application is reviewed, the government will approach you with something called TOR, which is Terms of Reference. That means if you have today got a piece of land and you want to start a pharmaceutical company, you think about what do you want to get. You want to get a machine, you want to construct it, you need to have an access to water, you need to have an access to air, you need to have access to soil, you will be using some chemicals for sure, and all of that needs approval. Now, how will government assess whether your construction is environmentally sustainable or not? Government will give you some pointers, will give you some list that these are the pointers on which you're going to submit as a report. And these are on that report, we will evaluate you. For example, when your teacher assign you projects in law school, they will tell you that these are the citation that you want to use. This is the research method you want to use. This is how you want to design your project. Accordingly, government give to the project proponent a detailed guideline on which you need to do a environmental impact study. Now, I'm a person who have started a company. How will I do it? I am not a geologist. I'm not a water expert. So how will I start doing all those terms of references, all those guidelines? I will start doing it by engaging an expert. And these experts are accredited organization, which are accredited with the government. And for example, there is SGS, there are a lot of different organizations which do environment clearance. You contact them and they will do it on your behalf. And these should be accredited by the government. That is one thing you need to advise your clients if you are into environmental lawyering and consultancy. And and once you delegate the job to these consultants, they will prepare a draft EIA report. What will that draft EIA report will contain? It will contain everything about your project. What is the quality of the water? What is the quality of the construction? Your sourcing of water, where the waste water is going, all of it, right? And on what parameters they will be making those reports, on the parameters of TOR, which is terms of reference. That means what terms you are referring to make your draft EIA. Now your draft EIA is ready and you submit that draft EIA to the government. The Pollution Control Board will have a look at it. And there are certain projects which are big enough, which will impact general people at large. Those projects will need a process called public participation. That means if in a village, you're trying to make a huge factory, and in that huge factory, you're requiring huge amount of water, obviously the groundwater depletion will be there. And if groundwater depletion will be there, nearby farmers or farms will be affected. And so you need to engage those farmers into dialogues before giving environment clearance, right? So this is the process after draft EIA where you do something called public participation. After the draft EIA has been approved by the government, usually you give a notice, a 30-day notice, and followed by 60 days reviews. You give a notice to general people. Now, how will you give that notice? You publish it on local newspaper, in regional language newspaper, where there are tribal communities involved. You do even drum beating by announcing that on so and so date, there will be a public consultation where there is a new project coming in your village. And if you have any issue with the new project, you can come to that public participation and you can start and you can voice your opinion about it. And we will record your opinion and we will have a consultation on that. So anyone can come to public participation. Anyone can voice their concern on public participation. But the most important information is people should know that there is going to be a public participation. People should be aware, and we are talking about villages where usually big projects happen. They will not be reading newspaper very lucidly in those spirits. So we need to communicate it to them. Once people gather on the decided on the decided venue, the project proponent, the one who is starting project, start a PPT or a video and explain villagers in detail that this is how they are going to implement the project. After they give a presentation to villagers in their local language, the villagers can put forward their opinion about the project. Each and every opinion is recorded, is subject to RTI, is a public document. The whole public consultation process is recorded, and you can file an RTI. Anyone can file an RTI and get a CD of the recording. Once the public participation happen, the public participation get attached to the draft EIA. If there are new issues raised in public participation, the committee asks the project proponent to review its project, to give more TORs, to give more consideration. Once those TORs have been attached, there is a final EIA, and that final EIA is approved. And once that final EIA is approved, the project can start after environmental clearance. So, and I've skipped a lot of technical details because I think this framework will be enough for us to understand what are the changes the government is trying to make. So the first step is screening. You screen the project, whether your project need environment clearance or not. You screen it and you try to know about it. The second is scoping. The scope of your project, what kind of TORs it requires, then public consultation, and then appraisal. Appraisal is kind of clearances is given to them. So this is the This is the whole structure we have right now with regard to environmental clearance in India as per the 2006 notification.
If I may just maybe intervene here and speak about how the Supreme Court has, and even the High Courts, how they've played a very important part, and they've contributed to the elaboration and elucidation of this concept. For instance, we are very aware of the Narmada case. There is, of course, the Tehri Dam project, the Narmada Dam project. There's a Samarth Trust case of the Delhi High Court, where the public participation, this aspect was very adequately, it was spoken of, and it was said that it is really giving voice to the voiceless. It is a form of participatory justice, and it is, they emphasize that when we are looking at, there are two aspects or two dimensions, the way it is envisaged under the notification, that there is the hearing, the public hearing, which came up in 1997 after 1994 notification. It was amended, the notification itself, and public hearing was incorporated. So later on in 2006, it's called public consultation. It has two dimensions. One of them is public hearing, where the locally affected persons, they are present physically to voice their grievances. And there is the other dimension, which is the written responses of people who are not so immediately affected, but who have some kind of as in the words of the present notification, a plausible stake in that project. Now, of course, Shashi would be talking to you about the changes that have come up and what kind of interpretations they may make. But it is a point, the public participation is an aspect which has to be, and it's an absolute must under EIA process anywhere in the world. But in all the notifications that have been there have been so many exemptions to this public consultation process and even to the entire process of EIA that it is really not understandable that when we have any kind of development project, for whatever reason, it and here the concept of mandatory versus discretionary model comes up, because India is up to 1994. It was an absolute. It was a discretionary administrative model that was followed. But after 1994 and the notification that has come up under Environment Protection Act, it is now partly a mandatory model that we are following, although there is a lot of administrative discretion which is involved because it is part of delegated legislation. So it is entirely up to the Ministry of Environment, Forests and Climate Change, and the kind of understanding that it has and how it proceeds. There have been more than 50 amendments since the time 1994 and 2020. And it was felt now at this juncture that there's a need to have a comprehensive, almost law on the subject. So interestingly, it is posited as a kind of notification. It is another notification that is now being a draft notification, so-called, that we have, but it is formulated like a law. So this aspect needs greater consideration. That is there not a need to have a complete law on the subject, or at least to integrate it in the main legislation, which is the Environment Protection Act of 1986, rather than having it as a notification merely under it.
Yeah. So touching upon the crux, as ma'am touched the nerve of the whole debate, where we really want it to be a part of delegated legislation from the main law. So we have Environment Protection Act, and that Environment Protection Act says that ministry can make laws on giving environment clearance. That's it, full stop. So it gives power to the executives to make a notification. And so it's a delegated legislation. And as in delegated legislation, we know delegated legislation cannot overpower the main law. So Environment Protection Act gives power to people, gives power to communities to raise their voice. And if EI notification takes away that power in some way, delegated legislation is ultra vires to the constitutional spirit of India in that concern. So now, if we see public participation as the nerve of environment clearance, there are some practical experiences that we would like to share that has happened over the past year. If you dig out the NGT's judgment since 2010 till 2016 for those 6 years, um, most of them are on environment clearances challenge. So once the environment clearance has been given, a lot of civil society members, environmental activists, environmental lawyers challenge those EI notification, or sorry, challenge those environment clearance. And one of the most prominent ground of challenging those environment clearances is that public consultation was not done properly. So you need to give them a notice in advance. You have not given that. The information is not given to them. Then you change the venue at the last time, and there is a pandal which they erect on, and on that pandal usually a district collector will sit, a project proponent will sit, and the panchayat head will sit, and all of them will sit in the panchayat. So the whole scenario is very intimidating for the villagers. If you're living in a village in a community spirit, you will not go against the panchayat or the sarpanch, or the district collector, unless and until you're rebellious. Now you want to live in harmony with the community, and you will not. And if panchayat has decided not to oppose the project, a single farmers from whom a lot of water is being dragged out will not voice his or her concern in that situation. So the whole environment of public consultation is not conducive, and a lot of time public consultation is being faked, and NGT has noted it. It's not mere an allegation, it's a judicial obiter being done by the NGT. So any prudent person will think that a new notification will try to address these issues which NGT has been trying to highlight from past 1 decade. And if we see the new notification, and if we apply the principle of non-regression, which means that any environmental law, human right law, which is there in a country, you should not regress from that. So if on a scale of 1 to 10, your human right implementation is a 7, your law should make it to 8, not to 6. So you should not regress in those areas. So if you apply principle of non-regression, which is part of India's jurisprudence, you're not supposed to degrade the environmental impact assessment notification of 2006. You should try to work to uplift it. And let's see then what are the changes which the government is trying to do. One of the first and the big change is coming up with a lot of definitions. So environmental impact assessment notification 2006 does not have a full-fledged full-fledged definitions. However, as ma'am said that we need a new law in it. So the new notification is like a new law, but not passed by the parliament, given by the executives. And the definition says that anyone who is accredited by the relevant authority can be the one who drafts your EI report. So Ministry of Environment and Forest can decide that who is an authority who can draft your EI report. Now you should know that the one who is drafting your EI report is the most essential person. There are incidences in which in the court of law, the NGT has observed that there is copy pasting of EI report. So for example, if you're starting a new factory in Andhra Pradesh, and if I'm starting another factory in Andhra Pradesh, your factory is for pharmaceutical and mine is for leather. And I will be copy pasting your report and just changing the proper nouns. So that has happened. And such such words. And in one of the incidents, I remember I happened to be in NGT, they forgot to even remove the proper nouns. And the judge was saying that from whom you're claiming to get the environmental clearance. So these practices were rampant, and environmental impact assessment notification from the principle of anti-regression should be doing away with these practices. But now MOEF CCC will be deciding on who is accredited to make environmental clearance reports. So that is one main point. There's a huge wide gap is being given and a huge wide discretionary power being given to the ministry that they can approve anyone to draft EI report. And there can be multiple institutions where the whole gamut or whole quality of EI report can drop down drastically, which is already a concern in the judicial corridors. The second thing is that up to a limit, now I'm not going into the detail how many hectares, acres are allowed and not allowed, but construction work up to a limit has been allowed without even seeking approval. So there is a category called category B2. And in that category B2, you don't have to get the public consultation done. You don't have to get the specific TORs done. You can just get the environment clearance. And there are more than 40 projects, 43 to be precise, in category B2, where such clearances can be given. A few of them are quite controversial, these entries under B2, because construction projects, as we remember, NGT banned a lot of construction in Noida, are included in those aspects. A lot of factories and renovation work have been included in those factors. So they don't require an extensive EIA process. And this has been introduced in 2020. Then, as I told you, the TOR is essential. TORs give you guidelines. TORs give you direction on how you have to do EIA. So there will be general EORs and there will be specific EORs. So if you're trying to do mining in India, there are 10 guidelines that you have to follow, no matter what kind of mining you're doing. And then there will be 5 to 6 more guidelines which are specific to your project. So these specific guidelines for a lot of projects has been done away. So you just comply with the general guidelines. You don't have to follow the specific guideline. And this is what 2020 notification is saying, that there are no specific TORs. There are direct TORs that will be issued to you. You just comply with the bare minimum and we'll give you the environment clearance. Another very important aspect is that you do not require more guidelines after public consultation. Now, what if a new angle is being developed after public consultation? Government is unable to apprehend what public is feeling. For example, there was a Coca-Cola case. Coca-Cola drenched millions of gallons of water in southern region of India. And when the environment clearance was given to that unit of Coca-Cola, no one apprehended that there will be a drought-like situation. But Coca-Cola pumped in a lot of water from nearby villages. And if you read groundwater law, you will understand that it's attached to the land. If a groundwater flows to a land, you perpetually become an owner of that water. And motor can make that water flow to your land very easily. So Coca-Cola drenched a lot of water from a lush green, well-stocked water region in India. And after that, a lot of farmers committed suicide within that region because of lack of their farm produce. And it was realized that because of that factory in that region, a lot of people have suffered. Now, this was not apprehended when an environment clearance was given to them. However, it was apprehended a lot later when people raised their voice. Now, during public consultation, if such matters come in, what is the logical conclusion? The logical conclusion is that authority will tell Coca-Cola or companies alike to do another study, right, before giving environment clearance. But that scope from authority has been taken away in draft notification 2020. You cannot give specific TORs after public consultation. And you cannot do it freely. There are provisions under which you can do it, but no one want to go into that bureaucratic glitch just to give new consultation. No, because activists are not sitting in the regulatory authority. So they will be normal people who are working under the government, and they are not allowed to give new notification or new guidelines after public consultation for the matters that have come up with. So that is again a very drastic regressive step toward environmental clearance, because when public have voiced their concern, if their concern is not turning into new guidelines, then the whole point of public consultation goes for a toss. And personally, that would be my main highlight or issue with the new 2020 draft. The notice has been reduced so public will be given only a 20-day notice that there will be a public consultation happening in your area. Earlier it was 30 days. Time and again, NGT has said that the notice should be at least 60 days. People are not aware. And if you pick up the environmental impact assessment report, it's a lengthy document. It runs into 500 pages with all kind of technical jargons into it. As a lawyer, it is very difficult for us to read it. How will a tribal community will read it, even if it's in their colloquial language? So you cannot expect those people to know that there is a public consultation, then read it thoroughly and critically within 20 days and come up with their response. And even if they've given their response, they know that it will not lead to another guideline to the project proponent. So the whole system linearly discourages the public participation, which was one of the most important limb, as ma'am highlighted initially. Uh, and once the environment clearance is granted, you need to give a compliance report. So if your factory is up and started and running, every 6 months you were supposed to submit a report that yes, all the guidelines and everything that you have told us, we are following it. And it has been changed to 1 year now. So the PPT says 1 month, it has been changed to 1 year. So I think I mixed years and month here. So it should be period from 6 months to 1 year. So self-compliance, earlier the report has to be submitted in 6 months, and now it has been changed to 12 months therein. Another very important aspect which you should know has changed is the upgradation and modernization of a project. So a lot of us hear the Vizag tragedy that has happened, and a lot of us hear that the clearances, environment clearance for that LG unit was pending. It was the modernization that was pending. So if a thermal power plant is running from 1992, of course you will do some kind of modernization into that project. Your thermal unit will be new, the way it processes energy will be new. And new technology means heavy technology, and heavy technology means the environmental impact will be different. So if you change the structure of your factory, you need a new environment clearance. And this is what EIA notification 2006 says, that you would require a fresh environmental clearance in conjunction with that is already granted to you if you're modernizing your project, if you're adding new thing to your project. However, to 2020 draft, the new draft says that you do not require a separate EIA for modernization and upgradation. You can do whatever you want to do with your project. And the only thing that you need to get is a no increase in pollution load certificate from State Pollution Control Board. So there will be no new public participation. There will be no new technical review of your project. You can just submit the basic document and get it from Pollution Control Board. That is again a regression, and it's again the policy or the principle of non-regression, which has found its relevance in Indian Constitution. Now, what if you have started your practice and your factory and you have not even applied for environment clearance? The new draft notification gives you scope to regularize that as well. So even if you have not applied for environment clearance and you have not got it and you have started your factory, you can later just pay some penalty and get regularized with the government. Now, it set a very dangerous trend where you can just start your factory, throw in some lakhs and crores of penalties, and then be okay with it. Right. So again, the project which are violative in nature are being given a scope to get regularized in India. And the last and the most important aspect is that if today you're doing a survey on your land, you want to know what is the quality of your land today. The data that you collected today will be valid for next 3 years. That means even if the groundwater level today on a scale of 1 to 10 is 8 in 2020, and your project is starting in 2023, that level 8 which you measured in 2020 is valid to get you environment clearance in 2023. So 3-year baseline data is allowed. So if you understand these technical aspects, you'll try to know that instead of facilitating the public participation in the environment clearance model, we are trying to restrict it through a lot of delegated alliance to the bureaucrats and to the executive, and giving a lot of free space to corporations. Now, being an advocate from the other side, from the corporation, we understand economy has to be boosted, and we need more projects in India, and we need to be a hub when it comes to new kind of technology, and such imposition of environmental clearances will discourage foreign corporation to invest into India. However, a lot of people who argue in those lines forget a one basic understanding, which is that economic if you have strong environmental laws in India, if you have strong environmental clearances in India, there will be more investment in India. A 100 crore or 1,000 crore corporation will not shy away from doing a good environment clearance because it helps them. If you do a good environment clearance, the project will be sustained for 30, 40 years. Never see environment clearance antithesis or a nemesis of a project. An environment clearance is for the project proponent, is helping project proponent to ensure that their project will be sustainable economically for next 20 years. You're not going to erect a thermal power plant just for 5 years. You want to make it work for next 20, 25 years. Now, if a government does a good environment clearance, in next 25 years, you know your project is sustainable. Your project is not going to fall apart. You're not going to create a lot of ruckus, and your project will not be shut down due to protest or due to unsustainability, right? So no good corporation will invest in India if the environment clearance is faulty, because they want environment clearance to be good and of a superior quality. And that is why in UK and European Union, there are a lot of investment being done by these powerful corporations, because their environment clearance is fast, speedy, but effective and qualitative. So our principle should not be on non-regression, but our principle should be upgrading our quality to ensure to facilitate investment. So this whole negative that environment clearance is a barrier to development is very wrong, is very misleaded. Environment clearance is an asset to development. If you give good environment clearance, the projects will be sustainable and it helps project properly. There are good number of businessmen who say that we need a good environment clearance process in India, and so this might not boost the investment into India, but rather we would have short-term project which will fall apart soon under this guideline.
Yeah. So I think just to add to this, and since we are almost at the end of this discussion, there's a range of environment impact assessment models that are there. There is, of course, at one end we have the rapid environment impact assessment, where the ease of business uh, that has become the paramount factor. And so there is an attempt to shorten the timeline as much as possible to bring it, within that kind of time range where it is feasible to start projects immediately. The other is the proper environment impact assessment, the process that we have presently. And the third is the strategic environment assessment, SEA, where you're looking beyond projects and you're attempting environment, the impact of even programs, policies, and much more. So that is, of course, a model which has been taken up by the developed world and not so much, by the developing countries. But at least on the EIA that we have accepted as a model, it is an imperative that the public consultation process, this component is retained, and it is in fact made more effective, because as Shashi said, it is going to bring in greater sustainability and greater acceptability of the project. And in fact, when we talk about ease of doing business, it should be termed as ease of doing sustainable business. So, in case we have that kind of a understanding and a concept and a idea of it, I think it can be. And we must remember that the public consultation, for a project which is coming into existence, the EIA is the only procedure and the point of contact for the people who can ventilate, who can voice their grievances and put across their point of view. And the idea is basically to mitigate those adverse consequences. It is not really so. So again, it's a misnomer that environmental clearance process, it not only prolongs the entire the way that the project is to come into existence, but actually it puts impediments. It is actually so that the project goes without any kind of a problem, and whatever environmental consequences are there, they are adequately addressed. Right.
So just on the conclusory note with respect to the environment clearance, there is a lot of misnomer, as ma'am suggested, that environment clearance process is seen as a hurdle. We also need to understand that we have a very well implemented and well adjudicated principle, which is precautionary principle in India. And it says that if there is a doubt on the impact of a particular project, on a scientific impact of the particular project, instead of giving it a yes, you give it a no. So if there is no scientific certainty that your project is going to be very good, or there is no scientific uncertainty with respect to its negative impact, it should be favoring of saying a no to a project rather than saying a yes. And this is a very, very strict principle, and India has adopted that principle. And a scientific study is needed. So basically, it mandates a scientific study before allowing a project. Now, if we apply EI in those contexts, it is a bit misplaced because a lot of scientific studies are discouraged in new EIA 2020. And in that case, precautionary principle may go for a toss herein. So summing it up, I would like to say that EIA process is an asset to corporation. And a lot of corporation recognize it. From big businessmen to oil and gas corporation, all of them say that EIA has helped them in other countries. Because as a project proponent, you would not know that what kind of environmental impact you're doing, which are going to affect the project only instead of people. It will affect the project as such. So India should go in that direction where it do a collaborative measure. All, even the government, even the corporation, and even the people have the same concern to have a sustainable project. Instead of facilitating people over corporation or corporation or people or getting into that debate, we should try to find a middle ground. And there are a lot of technical suggestions which have been given till now to ministry over it. And I think all the participants and people who will watch us on YouTube later on should read the notification again, should come up with their own comments, and should tell government, send into government their comments, which they really take into account and compile it. If you want, NLU Delhi Center, if ma'am agrees, can do it for you. We will leave an email ID for you guys. You can write your comments, we can compile it, and before 30th, we can send it to the ministry. And if you want to send it as anonymous, you can just mention that you want to send those comments as anonymous, and we would be happy to facilitate at National Law University Delhi. What do you advise, ma'am?
Absolutely, absolutely. That's a very good suggestion, and I think I would request everybody who's hearing in to participate now effectively. Since we are talking about public participation, so let's come up with our comments, suggestions, and try to have a document which we can forward to the ministry. Just as a last, I'm not the last word, but something as summing up. The present pandemic makes us realize how going against nature is absolutely it's the wrong way, and it's going to nature strikes back with a vengeance. So it's something to be kept in mind that even and the strange part is that this draft notification has come up while we are undergoing this whole uh, seismic kind of the situation which is there uh, on all of us. So just keeping this the ecocentric view, we've had so far a very anthropogenic view of things. And so let's change over our thought process, our mindsets, and let's try to have a more wholesome, comprehensive way of looking at projects and at EIA, which is a very, very important component. And it really helps us to achieve the objective of development and environment. Thank you.
All right. Thank you so much, both of you. That was one very enriching session. Uh, we have got a question from Miss Monica, I guess. So the question is that why are the EIA compliances eased rather than making more stringent laws when there are so many non-compliances by Indian industrialists? Any one of you who can put a
Want to
light
take
on
it,
this?
ma'am, or should I take it?
Shashi, please.
Okay, so as I've said, and ma'am concurred with it, and ma'am expounded on that, that there is a misnomer in industry which everyone believe that environment clearance is a hurdle. Until and unless we solve it, we will not have consensus of all the stakeholders. We need to make sure to effectively communicate to people the bounties of a project and how that project is trying to restrict them. So we need to be very transparent to us. We need to tell that Coca-Cola is going to drench the water, but it is going to boost the economy, and then try to find a middle ground of it, rather than going towards any of the extreme side which will make it sustainable. Please do not forget, sustainable development includes economy as well. Sustainable development involves economy, environment, and community, and we need to make sure all three of them are aligned. So if you make environment clearance stringent, and if you ask company to put 5 crore rupees worth water filter, and the company's net profit is just 2 crore, they're not going to come to India. They will go to another nation where they're allowed to put a cheaper one, right? So we need to do such kind of technological innovation where we facilitate company as well, where community also come together, and where economy is also boosted. I know I'm sounding very utopian when I talk about it, but there are models in which it has been succeeded. And to start with, the first step would be to get away with our prejudice and biases. We have to support all three: economy, the corporations, and also the community and environment. So a message to civil societies, NGOs as well, that we need to find a middle ground, and a message to corporations as well, that it is good for them only, and collectively a message to government that we need to find out a qualitative way to facilitate environment clearances rather than easing it out. So I think it has a lot to do with the mindset of the government and of the corporation and community as a whole, which needed to be changed. It's not a legal issue, is what I believe. It's a mindset issue.
All right. Waiting for more questions. Request the participants, if they have any more questions, they can ask us here. Okay. Now somebody wants to know that if you can send them the details of the NGT report if it is still under publication.
NGT reporting, in the sense you're asking for the EI notification. You can go to Ministry of Environment and Forest Climate Change website, MOEF-CCC website. They are open to have your comments on the draft. You can read the draft there and have a look at it. With NGT Reporter, I understand it's National Green Tribunal Reporter, where they publish the summary of their judgments. And there are a lot of independent law firms and NGO who does summary, but right now NGT Reporter as such is not publishing new volumes, is what I know. I might be wrong. So yeah, I'm not sure what to make out of NGT Reporter here.
All right. Okay, one question has come up that in most of the public participation cases, most of the time the public is unaware of the effect of the industry will have till the time the disaster has taken place. So how can public participation actually help in the EIA process? Very interesting question.
So do you want to take it up, ma'am?
I'll take it up partly. So essentially, when we're looking at the EIA process, the ideal way of proceeding, regarding public participation is to involve people from the first stage itself, which is from the stage of screening itself. That is a very ideal way. of course, we have a particular stage at which the people, are consulted, and that also is a very incomplete process because of so many technical, barriers which are there, whether it is in terms of vernaculars, the local language, or the very difficult and a very, it's the imposing uh, facade of having it in a very quick manner, not giving adequate notice and so on. So it is, these are of course issues which require more, and definitely when we are talking about EIA as a process which may resolve and which may actually help projects and industries, we ought to have a sound EIA. That's the premise that we are looking at. But this is an issue that how people are going to really, they are mainly ignorant, they are illiterate, the indigenous communities are there locally, and they may not be really comprehending the entire complication of the the verbose language and the technical part of the document. So it is here because there are two parts of EIA consultation. One is of the locally affected, and the other is the written responses. So one supplementing of the efforts could be by the NGOs and other people and organizations who can very effectively put across the point of view, and who may actually bring in their expertise, their experience, and they can put across through their written submissions. For the locally affected people, it is a much more difficult exercise because, yeah, Shashi, if you can just now step in.
Oh, okay. So, as very comprehensively pointed out by ma'am, that in case of public participation, there are people who will not know what exactly is the technical effect on them. And I keep on giving the same example of Coca-Cola. No one wondered that that so many farmers will end up committing suicide because of drought by a Coca-Cola company. Then there was a Vedanta black flagging which has happened, which led to a lot of farmers being killed, and there was a shot by the gun as well. And public participation has been turning violent since long. And when I was dealing with the hydropower projects, thermal power projects in the coastal lines of India, and where I went to a lot of public participation process. Trust me, the indigenous community, if being aware of the technicality of the projects, are better assessors of what it is going to do. As ma'am said, that they will not know the technical aspect. Once they know the technical aspect of the project, they can come up with a conclusion better than any AI accredited body, that this is what they're going to do to our environment and surrounding. So our job is to make sure they understand the technicality of the project, for which the government says that it has to be in local language. The full EI report has to be in a local language. And there has to be a presentation done in a local language, but by the project proponent. As a project proponent, you will not do a presentation which tells both good and bad of your projects, right? You will only going to say that it will transform your village, it will provide you road. It will not going to say that it will dug out water from your own well and it will turn it into a desert. So in that situation, we need to make sure that the civil society or the community or other people are also given the same platform as a project proponent when public participation happens. When that mandal or pandal is erected, instead of just project proponent, DC and the panchayat head, there has to be a civil society member or someone appointed from the people side who will project a presentation from a technical side and have a healthy debate over a project, rather than being a regular bureaucratic exercise. So that is one thing. And this also make the project stuck at NGT level. So if you just pass a project knowing it has grave consequences, there are a lot of good activists in India who are also lawyers, and your case will end up in NGT, National Green Tribunal, which same corporation wants a litigation nowadays. So again, I'm telling you, it's a very we can make an environmental impact assessment very conducive, just so that we acknowledge each other's problem in that scenario. So the answer to your question, I totally concur with Dr. Bharti here that we need to make the local community understand the technical jargon, and we can do it by giving the platform to them while doing public participation, which is not given to them according to the law at place.
I may just add here, because most of the public hearing, they take place within a single sitting. So
Hmm.
perhaps, we could, it could be looked into that at least two sittings are required, where, in the first sitting, there is the presentation made, and all the consequences, the good, the bad, the ugly, they are there presented. And then, of course, there's a coming back, and then the points of view, because there is some time, there's gestation lag, which is natural to understand the problem, to let it sink in, and to come up with possible solutions, or to even voice problems. So at least two maybe sessions, which we formulate as per document.
Yeah.
All right. One Mr. Shravan, he has given a comment. I guess either of your comments are required on this. He says that disempowering the EIA process of compliance will over-empower the state PCBs, where things can be more convenient to the project proponent. Further, CFPs and CFOs are still there to guard the environmental interests, but grant of EC without enough to technical data beforehand would leave the entire show to the regional environmental engineers. What are your comments on
I
this?
think definitely I totally concur with Shravan here. And this is what, in fact, I was discussing with Dr. Bharti before our seminar started, that there is a linear backbone being set to give the clearance. So if you read the whole draft notification and draw a flow chart, that from where the approval is granting and to whom it is going, you will end up in a linear flow chart. There are no scope of branching out. So when you branch out in an authority, you're giving scope of dissent, and you're giving scope of not dissent is not the right word, but you're not giving scope of disagreements when it comes of debate. Now, in this condition, you're giving a lot of empowerment to State Pollution Control Board, where people are appointed by the ministry or through the ministry or by the recommendation, and local engineers, which are again government official therein. So there are a lot of linear approval being there, and there are a lot of power being centralized to them. Now, it might seem that the new EIA notification is trying to decentralize the whole process. From ministry, it goes to pollution control board, from pollution control board to its engineers. So it's a grassroots level notification. No, but the whole hold is on the ministry, because ministry have vested interest therein, and those engineers would have vested interest with the ministry. So it's not decentralizing the process, it is centralizing to a certain extent, if I may get that critical therein. So I totally agree with this comment that it will give them a lot of discretionary power, and NGT will flood it with a lot of litigation. Not only NGT, but the constitutional courts will be flooded with a lot of litigation, in which we will challenge these delegated powers to the executives. What do you suggest, ma'am?
I agree. Absolutely. That point is a very sound one. And this whole aspect of delegated legislation cannot be unrestricted. There is a guide. A discretion has to be a guided discretion. So here we're not setting any kind of parameters to it. So in the context of environment, it assumes even more serious connotations.
Wherever there is may, that the engineer may do so, the pollution control board may do so, the environmental impact assessment authorities may do so. That may requires further deliberation, that may requires further guidelines, because may means you're giving them discretion to do something and without guidelines. So they can use their power and misuse their power to a great extent. Anyone who has read administrative law will know that delegated legislation and power has led to the floodgate, have opened the floodgate of litigation in India. And doing so in 2020 on environmental matter is certainly a regression to what we have had earlier.
All right. I think we don't have any more questions. So we'll end our session here. Thanks a lot, Dr. Bharti and Shashikant, for such informative and enriching session. I'm sure such discussions are the need of the hour as we need to keep up with the changing world dynamics. So I'm sure that this was very much beneficial for all our participants today. And since this will be available on YouTube always, so I'm sure that many more will benefit from this webinar. So before we bid adieu to you all, I would like to just inform you about our website, which is ebclearning.com/courses. Here you can take various courses given by industry experts and learn from the experiences of legal modules through our talk section. So we have panel discussions, we have different courses, we have various talks. I'll quickly walk you through the website. I'll just share my screen with you all. I hope my screen is visible. So this is our website. Here we offer a variety of courses. These are all from the industry experts, and we keep on updating the courses. All the amendments are added to the courses. We give you certificate after this course. And not only this, we have talks from the likes of Mr. KTS Tulsi, late Mr. Ram Malani, Professor Madhav Menon, and the likes. So obviously you can go through this, and I'm sure that this will be beneficial for you all. And of course, we have our YouTube channel, EBC Learning, where all the webinars are available till now. We have had a series of webinars, so you can go through this. We have parts of courses also available here. So that's about it from my end. You can follow us on Facebook, LinkedIn, and Twitter. For any queries, you can reach us through our social media handle and we'll get back to you. And as Shashikant said, that if you want to give your comments and you want them to reach the government, you can obviously contact me, and I'll connect you through to our speakers, and even they can give you the ID that they were talking about. So please stay in touch and please stay safe during this time. Any parting message for the participants from you, ma'am and Shashikant?
So thank you, Anusha, and thank you, EBC, and thank you, Shashi, for sharing this platform and views on a very momentous day, the World Environment Day today celebrating, and just at the cost of down, and there's so much going on in our lives. So please keep safe and healthy and try to be as aligned to nature, with nature, as possible. You know, whenever we drift away from nature, then there are consequences. So EIA is that tool which helps us to really keep ourselves aligned with nature. And for those words, thank you again.
Thank you, ma'am. Thank you for those words. I totally concur with what Dr. Bharti said. We been working together since past 4 or 5 years now, ma'am, and with the NLUD Center for Environmental Law and Policy Research. You can have an access at National University Delhi's website to the center. You'll find the relevant email IDs there. You can send it to Bharti ma'am's ID, which you can find on NLU Delhi's website, and get connected with us in whatever ways you can help us out to make the voices heard with respect to environmental clearance in legal domain. And yeah, take care of yourself. The COVID is really making us introspect, implore, and explore in all kind of ways. And we really need to find a middle ground of all the stakeholders and their interest, and that is the only way to sustainably live. And the COVID, the reason to cope up with COVID should not give us another reason to make a natural calamity. And the economic speeding up should not be the only parameters on which we give clearances is what we would like to foster. The sustainable development, however, should be. So please read the notification, give your comments. Each one of you is expert in your own domain, in your own life experience. What we have digged out, you might dig out something new out of it. And really, India needs to do that. And the government is open to the suggestions. Please write to us or write to them directly, but please do engage. And this is the best way to celebrate today, which is the World Environment Day, I suppose. Thank you very much.
Thank you so much, everyone, for joining us. Thank you so much to our speakers. Hope to meet you guys soon. Hope to see you in another webinar soon.
And thank you very much, Anusha and EBC, for always giving us a platform. Just a call away, and if they find that it is relevant, they always help us out to set up. And thank you everyone for participating here, and all the people who will watch us on YouTube. Then thank you very much.
All right. Thank you.
And thank you very
Take
much,
care.
Bhakti ma'am, for being our knowledge mitochondria, I would say, to connecting all the dots and give us all the bases and teaching us about everything related to environment. Thank you. Thank you very much.
Thank you all. Thank you.
All right. All. Take care, everyone. Stay safe.